7 o'clock. That's the time for the opening of the meeting. I want to call this meeting of the Washington County Planning Commission open. First of all, we'll have the pledge. It'll be led by Urban Day, and then the prayer by Jim Day. Would you please stand and remove your hats, please?
Please join me in the pledge. I pledge
allegiance to the flag of the United States of America and to the republic for which it stands, one nation, under God, indivisible, with liberty and justice for all.
Let us pray. Our Heavenly Father, we thank Thee for this another beautiful day. Thank Thee for the many blessings that You bestow on us each day of our lives. Ask for a special blessing on this Planning Commission meeting tonight. That everything said and done will be according to Your will, and that Washington County might be a better place to live. Ask these blessings and thanks in Your name. For this and so in Jesus' Your name. Amen.
First of all, I'd like to have our secretary to please conduct a roll call.
It appears that Lane Freiberger, Scott Modlin is absent. I got an email from him. The other 8 members are present.
All right. I have to adjust a little bit. On behalf of the Washington County Planning Commission, I want to welcome you to the April 9th meeting, and that everyone who appears before the Planning Commission is entitled to a legal right of due process. Therefore, everyone that is present who wants to will be given a chance to speak at the end of the meeting. We want to limit that to about 3 minutes of remarks. Those that are on the agenda are given 15 minutes to give their testimony to the Planning Commission. We will ask that when you are called that you please respond by stating your name, your address for the record. On that, we'll go ahead with, we've had a roll call. I want to go into the minutes. We have 2 sets of minutes.
We separated out the minutes for the last Planning Commission meeting, which was temporarily suspended to conduct a hearing that started a half hour after the opening of the Planning Commission. So those sets of minutes were circulated for each, one for the meeting, one for the hearing, and distributed by email. I don't know if I received any, my secretary sent them out and solicited any comments or remarks, so I didn't receive anything.
We'll work with the minutes first for the Planning Commission meeting, or do you want to hold both of them together? What's the preference of the commission?
No one has any additions or
Both of
corrections.
them together. Do I have a motion that way? Philip Marshall has made the motion to accept both as written and sent out. Do I have a second? Adam DeFore, second. It's open for discussion. Seeing none, we'll take it to a vote. All in favor signify by raising your right hand. All opposed, same. Motion carried unanimously.
I'm going to send these around and ask everyone to sign them, and then Lane, if you would, try to work those down to Travis Elliott once they get there.
All right, first order is on our old business. We had our public hearing. We instructed the subcommittee to go back and take those comments in particular items and redraft some language. I want want to defer to one of the committee members that want to lead that. Lane, do you want to lead this, or do you want Danielle?
I can run the projector if you want to talk and go through some of the different ones. It doesn't matter.
Sure.
Okay. You sign.
All right. And on this that is up on the screen is the current draft ordinance, and there will be some revisions on there.
Now, are we just gonna go over the changes to the draft?
Yes.
Could you turn on the microphones?
Is that better?
Yes.
All right.
There's extra. There are extra copies. Take one.
First change is section 401. Non-conforming uses.
All right. Go ahead.
And all of these changes you're about to see are based on comments by the public in the last meeting. That the restoration of legally established non-conforming uses, restoration of non-conforming use buildings or structures after fire or other natural disaster is allowed, provided the non-conforming structure is rebuilt to its original state. Changes to the original footprint of the non-conforming use building or structure after fire or other natural disaster require prior BZA approval.
All right. Any questions? Comments from the committee?
Essentially what this did was remove that 60% requirement or the threshold.
Yes. All right. Next order change.
Okay, section 405, this was strictly added. Non-conforming use ownership may be transferred. This was a clarification.
All right.
Section
405.
405. It's section 400, subsection 405. The next change was to a definition permitted use. The text of building or structure in use for 3 of the past 5 years was added.
All right. Can you explain some of the thought process with that?
It was to place some definition of time of use of a building. Other members of the subcommittee, feel free to step in.
Thought, Danielle?
I recall that was a concern that we had at the public hearing, that people were concerned that, how long could a building be considered possibly a non-conforming use or something like that? How long without having to be re-permitted and go before the Board of Zoning Appeals? And so we thought that if we use this past 3 of the past 5 years, that would allow if an unforeseen tragedy happened in a family and it took 5 years to get it sorted out, that someone in that family possibly could continue that operation even if it had been 5 years, if it had been in operation for 3 of the 5. It gave some time in consideration.
All right. All right. Any other questions?
Okay, next up is different parts of this apply in separate ways, or could be interpreted in different ways. So we tried to group it all.
So in other words, to abide by this, you must abide by A, B, C, and D,
Yes.
okay? And this 100 feet is a change of language from 200 feet, correct?
Correct.
Okay?
Still 200, still, excuse me, still 200 feet from property line, but only 100 feet from county road.
Right. If you don't come across the road, then you don't keep the road.
And we added the text, provided that all requirements of 701.2.2.1 are met. And what that is to make sure there's adequate turnaround facilities on the property.
Now, if I read this right, you're saying that if it's a road is a property divide, if there's a county road that's a property divide, then we're still have to be 200 feet. Sure. But if you, across the street, then it's only 100 feet. And
As long as it's not-
then our consideration was that, you know, one of the concerns was traffic flow, so that we made sure that no trucks or vehicles were backed out on the road. So the part with the proper cul-de-sac or turnaround took care of that. Okay?
That was the intent.
All right,
This is also what the requirements of the state is.
okay. Bill?
On section 8, on the 400 foot, must be located a minimum 400 feet from the fixed off-site. Can you describe that to me?
Well, that's not a change in the language. But it is 400 feet from the nearest point on the CFO, be it a lagoon, a corner of the building, whatever the closest point is to an adjacent property, a residence, house.
Is that third house?
No, it's a adjacent property owner. It's somebody besides the CFO owner.
Let me see. So, if somebody owns property right across from the CFO, and he's 100 foot, say, off the road, then the CFO, or the combined building then, on this side, only has to be 300 feet, taking 100 feet on the other guy's property, or the other property.
Yes.
How can we do that? Are we not infringing? And I know, and I'm just trying to work here, but are we not infringing on the other property owner's rights by using that 100 foot?
This is the same language as in the state statute.
From the nearest structure?
Yes. We took that straight out of the state, the IDM regulation.
But I will point out that by going from 100 feet or 200 feet down to 100 feet from the center of the road, in those cases where someone hasn't developed yet, well, we don't have reciprocal requirements to, so someone could still, yeah.
I know that was the talk at start on the reciprocal, but I was unclear on the details of the other house. So, right now, if a person lives 100 feet off the road, and a confinement building goes over here 300 feet, 400 feet in total, this person wants to come back and add something in his front 100 feet.
They can do that.
The setback is only for the confinement building, it's not for the residence. When the reciprocal language was taken out, that allowed any residents to come within closer. The language that is introduced right now is just to deal with the confined feeding operation as far as the site location, that it has to be a minimum of 400 feet from a resident. Now, it's 200 feet away from the property line, but if a resident was, 50 feet away, from the property line, 400 feet still works. I mean, it still has to be the 400 feet away from the residence. And the language was used off of IDM language.
Okay, that's what, I'm just trying to still play catch up here.
Yeah, the setback, the 400-foot setback is only for the confined person. The resident across the street, the adjacent property owner can do whatever, they can go wherever they want once the code's down. You just can't build within 400 feet of an existing structure, it's residence.
So 400 feet right now is the maximum distance of a CFO from a resident.
Minimum.
Minimum distance.
Yeah.
Did you find that air conditioner thermostat?
Yeah.
I got a tie you can wear.
And then we added a note, CFOs once constructed and having met all requirements of 701.2 are exempt from setback distances as defined in A and B above in relation to all future residential and public use development of surrounding properties. We did this to prevent an existing CFO to be impacted by encroachment. If a CFO is built, meets all setback requirements, if an adjacent property owner wants to build a home closer than 400 feet, they can, but it has no effect on the CFO.
Even on new construction,
Even on new construction.
okay? All right, any questions on that? Comments? Any? All right, Wayne?
Okay, 701.2.3.5 is actually quite similar to the note I just read. This is a clarification about applications. Once application is approved, the CFO is exempt from 701.2.1, Section A and B for a period of 180 days after which the application is void. Again, this is to prevent somebody from taking out a building permit to stop the CFO construction.
Understood. Questions? None? All right.
And then the last part is an enforcement. In the event new construction CFO is found to be in violation of this ordinance, fines of $250 per day will be levied from the date of citation until construction is halted. The sheriff of Washington County, Indiana will be responsible for the enforcement of this ordinance.
Does anybody know in code if that's a proper system of enforcement? Tom?
Yes.
Okay.
We've got other infractions similar to.
All right. Nothing's changed on the zoning map, correct? Okay. Last page of that document. Seen the ordinance, I'm looking for discussion with the planning commission.
Something just occurred to me. The setbacks from existing structures are from existing dwellings or existing dwellings. And I guess my question now is, now that we've clarified, that just prevents someone from taking out a building permit, at what point are we going to consider the 400-foot setback to be a measurable distance? Is it if someone has plans to build it, if they poured a foundation?
180 days.
Does it have, okay, explain how that's going to work.
From the time that a permit is approved for a CFO, they have 180 days to build it. That's the number that people agreed on the subcommittee that was reasonable. It's actually pretty generous to get a CFO built. We gave them 180 days to have it in place and built, and if they don't, they lose their permit. So that 180-day number would answer your question.
Except, what if I start building a house and I pour a foundation and it's not built? I've
for me in consideration, 180 days to start construction, it seems like a more reasonable date in there because depending on weather and that type of issues, you wouldn't have much control over that. But you could show as far as the intent, to go ahead with construction as far as keeping the 180 days. But a completion could be a lot of different things. I know some building construction can be blown down in tornadoes in the process, where there has to be a salvage operation and to put it back up. So those kind of lengthen those time periods as far as completion. I really think that needs to be addressed as 180 days to start construction.
Because we had the discussion about, do you have to have the permit before you can get financing, or do you get financing before you get the permit? And we were talking about how long it took to get, if you had to get an IDEM permit.
You're right.
180 days.
How long did all of those things take? And so I was very under the impression, Max, what did you think?
The completion date would be an arbitrary thing as well, because when do you count as completion? When the building is completed, or when the species occupies the building?
That's what 180 days, they started. Once they completed, had it done, complete, yeah.
If you meet all the requirements to build one of these things, and you haven't started it in 180 days, you should have to make sure that you are.
That was the intent.
That's,
All right, we need to change some language around in it to clarify that. Look at 701.2, 3.5. What language do we need to add to clarify that it is a start for the 180 days?
Well, I guess you would just say, you would add the text, for a period of 180 days, after which construction has not started or began the application for.
once the application has been approved, the CFO has 180 days to start.
You're gonna have a time factor based on the weather and all the other elements in there too. Because everybody's not gonna have 4 months of rain, but at the same time, that's gonna have to come into consideration. If some guy's trying to build
Sure.
and the weather interferes, you can't put a deadline on it in 180 days.
180 days is,
Yeah.
you're gonna get something done in 6 months. If you haven't got something done in 6 months, you need to make sure you still conform.
And that doesn't keep them from way applying.
Well, that's
You know.
just it, but you can't, if weather elements, then you shouldn't be.
Well, there's a lot of things that we're not going to have control over. But I think this gives a prudence to go ahead with construction and just have a bonus permit out there.
Yeah.
I think this exercise to truly to exercise the permit. Because I really, on the planning commission, I don't think we want a bunch of permits up in Lynn. I think that whenever we deal with subdivisions or anything like that, as far as what we do with dealing with that, there needs to be a timetable that there needs to be construction or something done with that permit. So to run that language, where do we need to add or put in this language?
I put on there, once application is approved, the CFO has 180 days to start construction, during which period is exempt from blah, blah, blah,
Or reapply?
or we will apply that.
Okay. All right.
Well, it does take the bidder.
applications, there's some confusion with this.
Too hot to think. I think that after talking to Danielle, kind of just whispering here, I understand what it's saying now, but on the first blush reading that, I didn't get what the point was. Basically what we're saying is, once an application, if an application for CFO is approved, that means it met all the setback requirements. So once it's met those setback requirements, no further construction or any, they need to get that started within a set amount of time. Otherwise, they can tie up the neighbor's property, and that's the intent, that's the big intent of this, so. Seems to me like the safest thing to do is they have to take some affirmative physical action on the property towards construction within a shorter time and have it completed within a longer time. Give them plenty of time to complete it. They need to start, I don't know, it needs 6 months to start. Or do you? Okay.
Well, the first they didn't find anything, it's pretty too late for stuff.
What if you put in there 180 days to start, 1 year for completion?
I don't know how realistic that is.
Because they could start and then just, they could still not, because there's no end requirement. It's kind of like me, I could say, hey, I could stake out a house because I don't want my neighbors to put in a CFO or whatever. It works both ways, and I still think we need to address that, which I raised earlier. Because someone could start, because we've not defined what start is, and we've not required them to complete it, we've just required them to start it. They could.
Well, anybody financing one of these days is going to want it, the bank is going to want you to get this thing up and going, they're not just going to. So, yeah.
Well, there's no requirement that it be financed by a bank.
That's true, that's
It's,
true. So, yeah,
Well,
I
they get you.
yeah, I know what you're saying,
Someone might not be real serious.
yeah.
I'll still go back to 180 days to start, a year to complete. That gives the end timeline of a year, and if it's not complete, then you're going to go back to, and I don't think that you want to be halfway done and have to go in there for a recommit process. That's fine. It's up to, we've had a request from one of the members of the planning commission to ask one of the people from the industry if that's reasonable.
Might ask Max about what he's saying on all this too.
Max?
What his understanding was.
My understanding was to be finished in 180 days, and I know what you're saying. When do you call the finish start? If you're gonna say finish time in a year, then that's occupancy of your animals maybe. To say that at least you got the back wall on and you can, it's ready to, if you're gonna have the 180 starting day and like the year ending date, just say, gotta have, to know that it's done, well, it's done enough to get animals in there, then you're considered to be done.
Do you think 180 days start is proper with the year end, or what's your thoughts, Max?
We talked about, they go up pretty quick, that 180 days should be able to get to an end point, but I don't know that that's, I'm kind of open to that, it don't really make that much of a thing, but the intent was so that a house, if somebody gets a permit for a house, to say that you can't build there, they have to be done in a certain period of time, or they lose their permit. I mean, that's kind of like the two sides of what they was looking at. Like Tom said, if he starts building his house, that you gotta show some sign of movement and that he's serious about it. If he's got to tie up your ground, the same thing you tying up the neighbors. So, the timeline I'm not sure of, but the intent was that if you're not playing the game, he's putting flags out there, I'll get my permit before he does, and stop him, or vice versa. Well, now he's flagging out for here. If you don't get the permit, then I'm in limbo. So it kind of forces somebody to get a permit and say, making a commitment.
Okay. Yes.
I think 180 days to start construction is reasonable. Again, to complete construction, again, it's difficult, sometimes 6 months out of the year to get construction done from dirt work you have to do. And like you mentioned earlier, as far as weather, we have had construction go up and a tornado or straight line winds knock the trusses down, and basically you have to start over again. So we're comfortable with 180 days to start construction.
What do you think would be a reasonable, if we put an end date on it, what do you think would be a reasonable number?
An end date for
To finish construction, like the building was in use.
a year we've done.
Years
State's
ago.
got 3 years.
Who said 3 years?
Who's did it?
Right, with the CFO permit, somebody has 3 years.
For completion.
Also an idea is if you want to end it after a year, maybe the ability to file an extension with reason.
Right. I think that makes a lot more sense.
Yeah, rather than just, rather
I
than
mean, I know we've got flat land and low winds all the time, but just in case.
yeah,
Okay.
that's, yeah.
One other point, our farmers who are building houses, they have construction interest in this building. So it behooves them to move along well so they can get that loan closed and start growing birds, so start earning income.
All right, Commissioner, we're gonna put some language together. My suggestion is 180 days start, year completion. If they're not a year, then they come back for,
I think they should have an opportunity to file for an extension.
extension.
Within a certain period of time before they, deny the, that way we can see a reasonable attempt for,
Would they need to go before the BZA for the extension or go for Travis?
I just think with Travis can walk in and see that, he can tell if they're actually doing something or not.
Gonna file an extension, why do you need to put a year deadline on it? Because like you said, some of them are probably gonna get there.
Most of them are probably.
So if they get there,
But if this is in the event that they don't, so that you're not automatically required to use a permit, you can file for an extension first. As long as you do it within, 30 days, just whatever, or you're,
so after a year, they're gonna go for the extension then?
yeah, after a year is gone by, you should have, what grace period, 10 days, 30 days, whatever, to file for an extension before you should actually have it filed, you should have it filed before that is under review. I mean, if you know you're not gonna be done, you have to file for that.
I honestly think they need to file 30 days prior to,
Yeah, that's what I'm saying.
30 days prior to the
The end of the year.
end of the year.
Yeah, the IRS doesn't give you a grace period to file an extension.
All right, well, I think this is gonna be rough language, I'd like to propose this out as proper language. Once the application is approved, CFO is exempt from 701.2.1, section A and B for a period of 180 days to start construction. After 1 year, if the project is not completed, you may file a 30 days prior to the expiration for an extension. I'll make a motion that way.
I have a question. Should there not be some increment here for the extension? I mean, you've given deadlines for commencement and for completion, and so if you're filing for an extension, I would think that should be limited to 30 days as well.
would like to have that request for extension come back to you.
I think it probably should, and there needs to be language for just cause. And what I suggest to go I say must be started within 180 days and completed and occupied within 1 year from the approval of the application, subject to extensions, subject to the right to petition for an extension upon 30 days prior notice. So 30 days prior to the deadline, they can apply for extension and appear before.
All right. All right, that sounds like all your.
And for a good cause, but I think it.
Jim, do you approve of that?
Yes.
Remarks? Do you want to make that as your motion then?
Yes.
Okay, do I have a second?
I'll second.
Okay. We have a motion to work with the language of 180 days to start, year for completion, being able to file 30 days prior to that anniversary, back to the Plan Commission for extension. It's open for discussion. Seeing none, we'll take to a vote. All in favor, signify by raising your right hand. Opposed, same. Motion carried, so we'll change that particular language. Tweak that, we got it. All right, the one in the notes that I had in conversation around, I have real reservations with this particular ordinance because I feel like we don't have a land use ordinance to speak of. We have a AFO, CFO ordinance. Because the description and the parameters that deal with residences and agricultural areas is only addressed by the setback language that a confined feeding operation has as minimum requirements from the schools. But we really do not give a good definition of a residence. You know, and I know that reciprocal setbacks was a very controversial subject. And at that point, I thought, you know, when we were addressing that language, we were going to address the residential aspects to the impact on agriculture. But we are trying to find balance and equal balance. That's my remarks on that.
So you think the definitions, the residence needs to be clarified for the residence?
Definition page. Okay.
Yeah, there is no definition for the
Building uses a home at least 6 months out of the year.
yeah, there is no.
That's your only definition. There's no other parameters. So what we're saying with this is that residences are exempt and can do anything, right?
That's pretty much, yeah.
I thought the intention was to write a separate residential.
Well, that's a subdivision code. But, I mean, we decided, I think it was September, October of 2011, that we were going to start small and address only confined feeding operations and possibly, I guess, mobile home parks or something like that.
The reason I'm bringing that up, you know, this is this one corridor that you're working with this land use. And while we're in here drafting language and stuff, we have subdivisions that go up in an agriculture area where there are confined feeding operations. And presents issues and controversy, you know, as far as setback language. And right now, there is no setback language. If you wanted to, you could take a subdivision and put it right up against a confined feeding operation. Not saying that you would, but that opportunity is there. Same thing as a mobile home park. That's the reason I address it.
I think that was a decision made over 6 months ago to do away with reciprocal setback requirements also.
Is that balanced?
Is that language not going to be covered in a subdivision approval? I mean, we're going to be writing requirements for a subdivision.
The subdivision code has to do with what constitutes a subdivision and the rules within, how subdivisions come about, not the location of them. The zoning code is where we'll establish residential and agricultural and all that. And right now, where we create actual zones where things can and cannot be. And
I
right
was
now,
referring to the setback requirements. The setback requirements will be whatever authority that's going to come under, not necessarily on land use.
we get, using the term land use, I mean, this is all, planning is land use, so that's, I mean, a zoning code is what we're drafting. And included in the zoning code, traditionally, a zoning code and a subdivision code in Indiana have been two separate ordinances. And over time, Washington County adopted some basic subdivision codes with modifications, which we recently clarified and recodified because of some discrepancies in the last year and a half or so, without really changing the overall scheme of what had been adopted. Is that fair, Mr. Sutter? There have been previous iterations, multiple 4 or 5 different iterations of a subdivision code. We're adopting a fairly common scheme.
So my question is, when do we address those particular issues as far as subdivision placements, trailer park placements, and agriculture? Because we only have two distinct zoning areas right now. We have residence, which is basically those zone cities, Salem and Livonia, being the only two. We have the,
Well, anything that is an incorporated town.
okay, the incorporated towns in the zoning maps, they're classified, but everything else is classified as agriculture. So when do you work with that language in an agriculture district with an ag residential development? When do you address it? Do you address it now, while you're addressing confined feeding? Not only confined feeding, we're working with agricultural period. Danielle?
I think the question is we think that this big majority of our county is agriculture, that's what it is. Why do we not think that residences cause a problem for agriculture? Because we think combined feeding operations cause problems in the agriculture zone. Do residents cause a problem in the agriculture zone? What other things? If this is what it's supposed to be used for, is ag. Why are we permitting every other thing to happen there as well? I guess is kind of the concern. Because that's the best land use.
I think Danielle makes a very good point. You can't impose stricter regulations on the less strict zones. For example, you know, just because you can't put a confined feeding operation on South Main Street in Salem doesn't mean you can't have a residence out in the country. And I mean, there are certain places where fast food operations and other commercial businesses are allowed, and then places that they're not allowed. And so when it comes to the choice of a residence can be in a commercial area, a residence can be in an industrial area, a residence can be in an agricultural area. That's permitted, but then there are some tightening of the reins when you start crossing those boundaries of what's a more restrictive zone and a less restrictive zone.
Right. Well, it seems, I don't know if there's a question still pending, but it strikes, I'm a little taken aback because it's curious to me that we're having a conversation about having some restrictions on residences and subdivisions and the like now, when we're not even going to consider, we nixed the idea of considering reciprocal setbacks. Because if you want to talk about imposing upon a confined feeding operation, I don't have a vote and I'm not trying to express an opinion even though I might have one, but it strikes me that a residence could waive the setbacks, park on a property line or real close to it, and create all kinds of havoc upon a confined feeding operation. And have a financial impact upon an existing confined feeding operation. And we elected nonetheless not to have any reciprocal requirements on residences. So if we're not going to try to protect those agricultural operations, I'm just,
We did, in a way though, with the property line setback. It's not a burden on the residents, but it does protect the CFO to some extent from encroachment.
right, to a lesser extent than in the reverse. But that was imposed. In fact, I think I suggested a 200-foot setback to maybe remedy that, or at least come up with a compromise. If that's the case, then idea of having maybe some industrial business areas or whatever. But when we when we hired a consultant to do this, the instructions were, all we were going to address was this. So,
Well, we were met with very negative feedback when there was even a possibility that we considered the idea of regulating what people couldn't do as far as living on their own property. And that was a very big issue with the public throughout the entire process, that people did not want their residential activities to be infringed on that zone. I mean, the first two things that are permitted uses are dwelling unit and home occupation. We want to be very clear that these are not regulated. Where people can build their houses and what color they can make them, so forth and so on.
the idea was that this would be established now. We'd address the agricultural issue, and it's not agricultural. I mean, there's no talk about corn and soybeans in here, let's be honest. That we would address one issue, but it would need to be passed as a zoning ordinance with a zoning map as required by law, and kind of the definition sections. And remember the last meeting, we had some questions about fences that are, as we set forth some general areas so that we could fill in as we went down the road, as we saw the need to add other areas, we could fill in. But again, I distinctly remember I wasn't at the meeting, I think it was September maybe of 2011, but I came to the October meeting, it was decided that this is what we're going to address and only this.
And there's nothing, I mean, I think the logical progression would be, assuming that this is adopted by the commissioners, would be to go back and look at rural residential land use, either as a modification to this ordinance or as a standalone ordinance.
There were
And start thinking about what the comprehensive plan was trying to do, which is to direct development.
Well, some of the things in the comprehensive plan, I know that we tried to direct development, whether it was utilities, the road frontage, those type of infrastructures that were there. You know, and that goes with industry too. Different zones we had presented were agricultural districts, residential districts, business districts, industrial districts, and then other possible districts, you know. So in our comprehensive plan, whenever we developed, we introduced that we've got two zones right now, but we've got this ideological view of other zones such as industrial, business, and involved. And I think that we are residential. I just don't want this plan commission to lose focus that, you know, whenever we just work with this CFO, it doesn't stand alone as an island, because there's a cause and effect all the way around as far as the different entities of involvement, as far as the economics and the viability of investments, not only of the residential, but also of the industry themselves. So we have to work with balance in whatever we do. Okay? I wanted to bring that up because it is a concern of mine, because I see that as a void in this.
And ultimately, I think we've got 40 members since a lot of these discussions took place, but a lot of what we talked about months ago when we started down this path, we decided we were going to address the subdivision code first. We elected to address the immediate problems with our existing scheme, which I've already talked about. And then once we undertook the zoning code and addressed some of these issues that are before us here in our present draft, then to revisit the subdivision code where we reconsider the entire scheme on how we do that. And because that was quite an undertaking. Jeff and I met, you know, and talked about it, and
migration as far as population densities, as far as increased setbacks, to deal with population density. And I think that at that particular time, whenever we were doing that, we were trying to identify those populated residential areas as far as the migration of AFOs and CFOs, that was the proper location, because the setbacks got larger as the population increased, so it became more cumbersome to find an area in a populated area for the confined feeding operation, that you would possibly look for a relocation of a less populated area. And I think that's about as close as we got as far as addressing the residential CFO issue. Okay? I'm not going to belabor, I just wanted to get the comments, on that particular issue. Is there anything else that you want to address as far as the ordinance?
Was there some discussion, any thought given to these zones, and maybe, did you, I was talking to Elaine in the last meeting, or Jeff, one of you, about maybe reconsidering how we did that, and you really want to label the towns and cities as residential and everything else agricultural. So I thought I had, somebody approached me with a thought at the meeting, I don't know if that got incorporated or not.
Well,
Okay, all right.
we can always modify the map.
Oh, yeah.
I mean, it can be changed.
I mean, it'll be another public hearing process, et cetera.
But it's, we gotta have something to do, But yeah, eventually, the one thing the ordinance does not say is what is allowed in a residential district. I don't think, does it say that? Or what is not allowed in a residential district. It might, I heard you clarify that.
Right, and the idea being, because we elected not to regulate anything other than what we're regulating, there's no provisions, but there's room for that down the road. Now, the one thing, I raised an issue early on that still has been, I think, unaddressed, and that is the reciprocal of the, what if I start building a house myself and have a, does it have to be completed? If I'm in the middle of construction, but I don't have a completed house, and someone come in and place, plan, apply for, and place, define feeding operation is fine within the setbacks here, where my house isn't completed. Because I don't qualify as a residence, used as a dwelling or whatever, 6 out of 12 months, because it's under construction. Do we want to address that or not?
We can do that idea.
Max, when he commented, he said he felt like the idea was we were trying to do it both ways, if I understood you correctly.
That's what we didn't get it out there, but that's what I had in my head when we were talking about the 180 days.
And I don't know if anyone else was thinking the same thing or not, but it strikes me that that's a foreseeable, we're trying to address an issue for a reason, because we can see a problem coming up. I think the problem works both ways. If we're going to address it, we might want to address it in reverse as
I
well.
think we need to change the definition of residence a little bit, and include that, residence, or under construction, and there has to be some time limit on that too. See what he's saying? Because our definition of residence is lived in 6 months out of the year. And to be used as a residence, 6 months out of the year.
All right. We have a motion, we got a second. It's open for discussion. To change the definition on residence. Yes? Bill?
Ask Travis a question. How long is the building permit good for?
Year,
1 year?
unless someone requests for an extension, they can do that. It doesn't happen very often, but
Or you want to add that to it?
It's, a building permit isn't even required in Washington County if you're building your own house, so this covers it better than the building permit.
All right.
it's in Indiana, just to be clear,
Indiana,
not Washington
Indiana,
County, it's in
yeah.
Indiana.
Anywhere in the state of Indiana, in any unincorporated area, if you're building your own house, you don't have to do a building permit, state law. So this covers it better than saying something about the building permit for the house, which is, may not apply.
Any more discussion? Call for question? Seeing no more discussion, we'll take it to a vote.
Question.
Question, okay.
No, I was saying question.
We call for question, we have call for question. Do I have a second?
I second the call.
Adam is second. All for a call to question, signify by raising your right hand. All opposed, same. Motion that we have on the floor is to change the definition of residence as a building used or a building to be used as a residence at least 6 months of the year. All in favor of that change, signify by raising your right hand. All opposed, same. Motion carried. All right, anything else to discuss on that? Any other issues?
I missed 2 meetings, so I don't know anything that about this a lot. But, committed uses,
Okay,
will we go to,
page 9.
will we go to, where it says, retail businesses for the time? Will we go to, be a little more particular about that, or?
We don't like to really pin things down.
Well, that's good sometimes.
I mean, when you're in that culture, everything, you know.
Yeah, yeah. Well,
think that the intent, you know, of some of the conversation prior is that, you know, like the side markets, farm markets, they would be classified as retail, you know, even though it'd be agriculture. You know, you could have a chainsaw.
Sure.
You could be classified as retail.
It is a retail business.
So, now, so do you want to restrict that definition of retail?
Very little.
Very little.
That's the point I'm making.
Then how do you want to do that?
Well, what I would propose is pretty simple in there, like retail businesses of any kind with the exception of those who are
I think by law, you actually, if you were to do that, you have to allow a place for that to happen. Correct?
Again, this wasn't an issue that has crept up until spontaneously right now. The email that I sent out 3 months ago, that didn't bite, nobody got on it. But this does require some First Amendment issues, okay? And I'm not prepared, because I didn't come to this meeting having done research on that, because I didn't know this was going to come up. Because, again, no one had taken the opportunity to ask that this be looked at. But I do believe that there are First Amendment speech issues, and if we restrict it, we have to at least provide a place where people can address it. I know that these types of things have been challenged and litigated around the state. And I've not looked at any of those. I don't know how they come out. I don't know how any court decisions have come down. So it's not an issue that come before us.
Yeah, so it's something we can always address on the end. If it's not something we're prepared to address right now, then not.
Well,
Because we definitely need to know what we're talking about. Because and I don't know, I'm not looking into it all.
In looking at Harrison County, I did see that there was a specific section that dealt with just what we were talking about. It's in here, and it basically designated an area in the county where that was able to happen.
Probably do that for a reason.
Well, there is for one in-law, just like Tom was talking about. So, do you see a need to change that retail language in that as we go on?
We could change the language to say retail business, parentheses, any kind except as restricted by subsequent ordinance. Close parentheses.
So what does that do?
nothing. Because I think we just pass a subsequent ordinance to change it when we need to.
Yeah. Or amend this ordinance, so it really,
Yeah, I would.
it's the same just the way it is right now.
Yeah, that's the same. I just, if we're gonna address that, we need to address it, modify the ordinance.
We're not going to do that to our meeting.
Yeah, it's in here, and I've got it, I've got the Harrison County ordinance right there. All right, now, understanding, we've got some discrepancies as far as some language. I mean, does this planning commission, where do you want to take this? Do you want to go back and more discussion with this ordinance? Review these comments that we made, you know, and maybe actually address where we need to stand with industry and residents, to agriculture and agricultural district. Do we need to address that? Or do you feel comfortable with this ordinance to put it back out for public comment?
I feel.
We're going back out in public comment? Okay.
We just need to,
I think this is a good start for ordinances to start with. As far as adding anything else right now, it's going to help us in to add more right now.
I agree.
With that, I'll entertain a motion to go ahead and present this ordinance out for public comment.
To have a public hearing, maybe?
Yes. stand
I
up.
would say
I'll make a motion,
subject to the revisions. made.
subject to the revisions that have already been approved by the planning commission,
Okay,
that we go ahead and schedule a public hearing and present this to the public.
okay.
I'll second that.
All right, Jim Day, motion been made by Adam before, and second. By Jim.
No, Lane.
Jim Lane made it. Jim second. Okay, it's open for discussion. Seeing none, we'll take it to a vote. All in favor of taking the revised ordinance and presenting it up for public hearing, signify by raising your right hand. Opposed? Same. Motion carried unanimous. All right, do you want to have this at our next scheduled meeting for the public hearing?
I'd say.
Yeah, I would think that'd be that, because of the day.
All right? That would be May the 6th at 7 o'clock p.m. here at City Hall. I have a motion to go ahead and make that the date for the public hearing. We need to go ahead and make all the,
May I suggest that we do it like we did last time and maybe have,
plan commission and
or just to address, because there are gonna be revisions made
Yeah.
and it'll be posted for comment, but we might wanna have an opportunity to address those and see them in final form as it grows.
all right,
We'll start with the meeting and then adjourn to go into the
But
hearing.
we will suspend, not adjourn, and then have a public hearing at 7:30. That's what we did last time, we had it.
I think it's best.
all right.
I make the motion.
Okay, we made the motion, Adam has made the motion to have at our the regular scheduled plan commission meeting at 7 o'clock with a public hearing following at 7:30. On that, do I have a second?
I'll say.
Lane Feinberger is second, that is on May the 6th, 2013. It's open for discussion. Seeing none, take to a vote. All in favor signify by raising your right hand. All opposed? Motion carried unanimously. Okay, scheduled for public hearing on May the 6th at 7:30 for the public hearing. Planning Commission will be at 7 o'clock.
I got a question for Tom. Since the planning commission as a whole voted on these changes, is it acceptable to circulate this thing to the entire planning commission by email to make sure we get the language right?
scooters. And with his business application, the application has to come to the planning commission for him to say that he is in no violation of any of the ordinances. We have none that restrict this, so I ask for a motion to sign this for the approval.
So moved. Second.
Jeff Souter, Phil Marshall, second. If there's any discussion now, if not, we'll take it to vote. All in favor, signify by saying aye.
Aye.
All opposed, same. I changed it around, I wanted to hear everybody talk this time.
Made the motion, second.
Jeff,
Made the motion.
Phil Marshall, second. All opposed? Okay. I'll take care of that at the end, make sure I'm on the right line on that. Next, we have Fred Schlummer.
Actually, it's Charlie Spears' law partner, Richard Middleton, who's speaking.
All right.
And he's representing our resident advocate.
All right,
for
please.
Air Springs and Streams.
You're the citizen of Washington County. Present your address, please.
9161 State Road 160 East, Salem 47167.
And you are deferring for comments to
Richard Middleton.
Richard Middleton. At that time, Richard Middleton, you have the floor.
Thank you, Mr. Chairman. For the record, let me introduce myself. I'm Richard Middleton. I'm an attorney in Savannah, Georgia. I'm Charlie Spears' law partner, and I'm here to address you. I would sit down, but there's no chair here available. To address a couple things with regards to this proposed farm that's going in. One, Mr. Chairman and members of the Planning Board, is the testimony of Al Heber. Now, I understand Dr. Heber has been here. I know Dr. Heber personally. I have personally deposed him under oath, and I've cross-examined him in 2 trials in Missouri. And I want to talk first about what he is and what he does. Number one, Dr. Heber is like lighting the fox in the hen house. He is an advocate for the animal feeding operation business, the industry itself. He has never shied away from saying whatever is necessary to make his point. He has been questioned on his credibility ad nauseum, and I want to, if I may, Mr. Chairman, I have a couple things I'd like to share with the board. In a trial involving common law nuisance, a cause of action which is not unique to, and it's not new. It goes back, as my fellow bar member sitting with you will know, to 1610 in Old England, in the William Aldred case, where the court, in its typical Old English prose, said where somebody wanted to put a hogsty 30 feet from his neighbor, it said the neighbor had a right to uncorrupted air. It has been the basis of the English common law, and it has been the law of this land state by state. So if there is a predisposition to approve this permit, which many of these residents oppose, I would suggest to you that there will be a return, but not to Washington County. This will be litigated if the people's rights are harmed and their enjoyment of their own property is infringed upon. Dr. Heber, in a case called Turner versus Premium Standard Farms, was asked by Premium Standard Farms, which was the second largest pork producer in the country until they were bought by Smithfield, which is the largest in the world, to monitor air emissions from hog facilities. And I understand this is a bird facility and not hogs, but this goes to what Dr. Heber is all about. And so this was an aerial map, and these white areas are the locations of the various barns at they call the Ruckman complex. He put his odor monitors right here, opposite 14, 15, 13, and 17. It was very interesting that we had barn population numbers from PSF, and we knew when the barns were populated and when they weren't. Same thing at the Homan farm, another PSF facility. He had his odor monitor here, and the closest the closest at Homan. He didn't have the barn population numbers. We took his deposition, he was under oath, and he was asked these questions. Okay, position that I took. The first location where the air monitoring occurred, he said yes. Who selected that site as the first location for air monitoring? Answer, it was selected, there was a site selection process that went on. And I participated in the site selection process. And PSF, being Premium Standard Farms, participated in the site selection process. And Mark Anstetter, who was a lawyer for PSF at the time, participated in the site selection process. We went on to ask him, additionally, and started asking him, do you have any idea whether the barns were populated or not? Because if you were trying to measure coming off, wouldn't you want the hogs to be in the barns? He said, you have no reason to believe that they were not at full production because you believe that they've told you that they're at full production, correct? They have told me that. They have told me that they were at full production, and although I didn't physically count the animals, I believe they were at full production. I said I believe they were at full production. I have no evidence otherwise. There's no indication they weren't at full production. Dr. Heber is a person who is so loose with the facts, and he was so confident that he could win on this point that he said this, the point that I'm trying to get at, doctor, is if you're going to come in and you're going to do a study anywhere, don't you want to know about all the factors that can affect your study independently? Don't you want to be the one to know, say that this is the case, that you know in fact that this is the situation? Dr. Heber says, sure, I agree, we should know, and I'm making the assumption, and I guess I'm putting my neck on the line, because if there were no pigs at the facility, then I guess my neck is on the line, right? And of course I agreed with that. This is what we found when you went, and I won't belabor this, Mr. Chairman, but when you looked at Ruckman 16, one of those which I showed you, from 12/23 to 12, starting at 12/23/2005, this is the number of the facility, this is the date. If you look at 12/23, the barns were empty. And this is according to the records that PSF gave us, meaning he concocted this study with PSF in a way that would show the problem with odor. He had already come to the conclusion, he just put the study together like that. And we'll see again that that's not unusual. Here is Ruckman 15, the other barn closest. And it goes from December the 23rd, 2005 to January the 5th, 2006. Look at what happens then. Down here, it's 12/17 all the way up to 12/31 and beyond. The barns were empty. That's what you all have been, that's what this man does. And that's what he tries to get away with. And I could go over the Homan figures as well, but we found out that everywhere he actually conducted a study, he had it rigged so there would be no odor because there were no pigs. That's not even low technology, that's no technology. Now, we know that he came before this planning board and he talked about his name study and that he conducted that. Let me talk very briefly because I understand at the last meeting, I stand to be corrected if I'm wrong, that Mr. Chairman, you were provided a copy of it's the Animal Feeding Operations Emission Review Panel of the US EPA. He said that study was in fact accepted. In fact, the Science Advisory Board wrote this report criticizing it terribly. The name study was this. They took 20, and it put up $1.5 million in Dr. Heber. The name study looked at 27 animal and bird operations nationwide. Everybody knows that there are 4 source points of odor and other contaminants on any CAFO. You have the barns and the animals themselves. You have the manure retention system, whatever that may be. You have the land application process, which spreads the footprint of odor on how many acres and however they land apply. And then you have the handling of the dead animals or dead birds, whether they're composted, whether they're carted off to a rendering plant, however they may be incinerated. So we know we have 4 main points of odor that offend the neighbors. And that's what we're here about, is the rights of the neighbors before this CAFO goes into effect. We know that in all 27 facilities nationwide, without regard to climatic conditions or anything else, that they only studied one source point on each farm they looked at, be it hogs, dairy, broilers, egg layers, or whatever else it may, or turkeys. That they only took approximately 5 dairy farms. There were 4 or 5 hog farms. There were 3 or 4 chicken facilities, and it turned out to be 27. But they never got a comprehensive understanding of what was happening at any one of those facilities because they only looked at one source point. They may look at the lagoons at a farm in Indiana. They may look at the barn emissions at a poultry facility in San Joaquin Valley in California. So the NAME study has been roundly ridiculed, led by Dr. Vinny Aneja, who on the report that you were provided, sir, he is a professor of the Department of Marine, Earth, and Atmospheric Sciences at NC State University in Raleigh, North Carolina. And that is a land-grant university that is very receptive to the CAFO industry. He, though, is independent, and he is one of the people who led the severe criticism of what Dr. Heber is doing. Now, I don't want to belabor this. I understand there are very strong opinions. I am not against farmers. I grew up on a farm in Virginia, raised 900 cattle approximately at any one time. Most of my clients nationwide, when they fight these CAFOs, are indeed family farmers themselves. Probably 85% of my clients are family farmers. But we have fought this battle in Missouri, we fought it in Minnesota, we fought it in California, we're fighting it in North Carolina now. And I will tell you that if this facility goes in, and if these people who are opposing this facility are adversely affected by what happens, and if they lose the right of use and enjoyment of their own property, and it doesn't have to be confined to a residence, it can go right up to the property line. If that's their property and they don't have the right to enjoy their property, and the odors and insects, other vectors that may affect them, do in fact affect them, then we're going to be back, and we won't be here in Washington County. What's going to happen is we'll be in a courthouse somewhere in Indiana, as there are other cases now, not against all CAFOs. I have turned down many more cases than I've accepted, but where they are doing something that they could do otherwise and cause less harm to the neighbors who were there first. I'm listening to this earlier discussion, and I don't think that there's, some of these things are the concerns that I heard voiced, because if you move to the nuisance, you either have statutory protection in some states, or you've got a common sense defense that the jury's going to pick up on. But if in Indiana and if in Washington County, these people are harmed by this particular animal feeding operation, and I understand it's a bird facility, it's planned, then it's not over. We'll be back. And what happens with common law nuisance is, for temporary nuisance, it's whatever the jury in whatever form we are. And it won't be here in the friendly forum of Washington County. It will be somewhere else. It may be in federal court in New Albany. It could be a number of other places. It could be in Indianapolis. But when that happens, a jury will decide, and it's open-ended on what the damages for temporary nuisance are. And the thing with temporary nuisance is it keeps coming back, because you can't have future damages for temporary nuisance. So you have the lawsuit, people's rights are either vindicated or they're denied, and then if they are vindicated, then they get to sue immediately again if the changes aren't made. So what we are about is making sure that if facilities go in, you have the proper recommendations that you need, and it's done by somebody with credibility, not a shill for the industry. And if you don't have that, then the property rights of the residents of this county should be paramount. A person's home is their castle, and we think nothing should interfere with how they use their own property and how they enjoy the use of that property themselves. That's all I have. I'm happy to answer any questions, but we would hope that you all would take a second look at this and be very, very careful in your analysis. Yes, sir.
My recollection of the purpose of Dr. Ebert's appearance was really to address some documents that have been passed out that quoted for another. He wanted to address possible misuse, and he did not address any particular application for CFO or any individual instance. He did talk about the study, because that was what had been previously presented and quoted. And he talked about how he just, when asked about general advice, how he felt like if we didn't take into account wind and how that might carry things, that probably we could do better. And referred us to a model that he put together. And if anyone had a chance to play with that, quite frankly, in some instances it suggested that setback should be more than what's being recommended here. So I don't want anyone to think that he was here to advocate or argue or prepare an opinion as to a specific scenario or application. He was contacted because he is a professor at Purdue University and felt like maybe some testimony or some documents had been presented to the commission for consideration that, in his opinion, unfairly characterized some of his statements. He did give an overview, he did point out several things, and it may be perhaps, and I understand that you've been requested to come here by some people who have a pressing issue personally with respect to their property. But his comments to the commission he was unaware of any specific applications, planning permit, anything like that. He was here to address something that had been presented that had his name on it, and he felt unfairly characterized his position. Is that fair to say?
That may be.
So.
But I, having had these personal confrontations with him in depositions and in trials, civil trials in Missouri, twice now in trials, I can tell you that in both instances, the jurors who were questioned afterwards gave him absolutely no credibility on what he had presented. And I would hope that you would understand that if he was like that with industry then, I doubt he's changed. He's at a land-grant university. They are well supported by the agriculture industry, and I would support him to continue his loyalty and respect to any comments he made, specifically or generally. But thank you for that observation.
The document that you're talking about, I was given a document that I think that you're referring to by the EPA. It's to the Honorable Lisa P. Jackson.
That's correct.
Yeah, this is the document?
Yes.
Well, I've read it, and I was prepared to make statements back on 2/22/13. And whenever I was presented this document, I was prepared in March to give my remarks back. That person did not show back up for those remarks. But I did read that document. It was given to me, that said if I had trouble falling asleep, that I could read this and it would help me out. And that was very true.
Might be overly optimistic.
Okay. I did review the document. And the statistics verification was questioned because of the number of operations used in the study. That was one of the arguments. And then there was also in there, it says, low monitoring values or negative values were scrutinized because the capabilities of the equipment to read such low levels. So the equipment not being able to read extremely low levels actually showed negative impact. Now I saw in your map there, as you've been there, you questioned in one particular building, which was the nearest to that location. But there was multiple buildings all the way around in that location.
Sure, but if you're going to measure odor and you take all the animals out of the barns that are closest to the monitoring equipment, you're not going to get any high results. And that's exactly what he did at both Homan, which is one complex, and Ruckman. I have the home and
So you're
grass
saying
here.
all those buildings were empty?
No, the ones closest to the odor, to the monitoring equipment, were all empty exactly at the time he ran his tests.
All right,
And he said that he had decided on the protocols to be utilized in conjunction with PSF's employees. Well, these are the PSF population records. We know those barns were empty. And so if he did it in conjunction with them, and he decided where the location of the monitoring equipment would be, regardless of the efficacy of what it produces, then, and you empty those barns, you're gonna get the lowest possible levels, and that's what he was trying to do.
well, that's an interesting scenario. The argument was also, that in there, that management practices have had a larger impact, in there, especially the cleaning and applying, feeding and watering and size of animals. We're not separating a report on types of report. The report actually said those had a larger impact, as far as best management practices than the actual building.
We have some CAFOs, we see great management practices. We see
So-
many others that are very slipshod. And the result is, when they are not up to snuff, then that's where we see the biggest problems and the largest number of complaints from offended neighbors.
All right, and then I think also, this is where the conclusion that we can come up with, even in this report and even in Al Heber's report to it, that climate and topography implications of specific sites were limited for that location, and poultry was in Kentucky. We do understand that topography and wind direction and all those in the climate have a dramatic impact as far as, as far as the odors that are emissions from those operations.
That, I agree.
Now, our dilemma here as a plan commission, whenever we're trying to develop in there, is that we cannot regulate best management practices. Now, as far as ownership of those farms and to the industry, I think it's in their best case, in their best interest to use best management capability. Would you agree with that?
Of course I do.
All right. So, the thing about it is, everybody comes to the Plan Commission, wants us to solve even, the salt in the ocean water, but we can't do that. There's only certain things that we can do, and we're trying to implement a certain amount of balance. Because there are people in this room that our residents are very concerned with, such as your client, but there is a strong agriculture community in this county too. They're very concerned about what implications as far as how this happens and what happens to agriculture into this area.
Well, I can tell you this, that if this planning board, this planning commission, allows what to happen in Washington County, Indiana, that has happened east of Interstate I-95 in eastern North Carolina, you will turn this county, this is my first visit here. It is pristine. I've seen some beautiful land, beautiful countryside, but you'll turn it into an open sewer if you allow the wrong people to come in. And I don't know how you make that judgment ahead of time, but the after effect of it is tragic. There are 800 abandoned waste lagoons in eastern North Carolina. The bird industry, turkeys and chickens, are not regulated at all. You're only talking about hogs. But where they went with open arms, and they had legislation that passed, and where they had favorable ordinances that were favorable to the industrial agriculture industry, what happened was you now have eastern North Carolina has basically been ruined, and the rural population is who's taking it on the chin there. And what you normally see is these operations go into areas where the people are probably less organized than in other communities. They're sometimes poorer, lower income areas. They have less ability to fight back. The only recourse they have is the court system. And we already have cases here in Indiana. We will protect the rights of these clients of mine to the extent that we must. I would hope that could be avoided, but in the event this facility comes in and causes problems, there will be another day. In the event it comes in and behaves and conducts itself with best management practices, and it is not an insult to these people's enjoyment of their own properties, then it'll be another question entirely. Thank you very much.
Thank you. Very good.
I've got a question.
Yes, sir.
I'm just a little bit perplexed. And this is kind of a general comment. But do your clients understand that what we're trying to do is largely to adopt something very similar to IDEM regulations, but we're trying to lower the numbers of animals to capture operations below some number that the state says. That's what we're trying to do. We're trying to do something balanced. And currently, there are no regulations, zero. And if, you know, if your intention is to intimidate this board into not passing this ordinance, then they're worse off.
No, I'm not even talking about the ordinance. I was here addressing this proposed CAFO that is up for consideration.
But we're not,
We don't have
we
one.
don't have ordinance.
That we're trying to draft. It doesn't even come to the planning commission.
It goes
Well-
in without any input from us.
Well, I understand this particular CAFO has applied for a permit. Am I wrong?
I didn't.
Not from us.
Well, you know what, Charlie Spear, who couldn't be here because he's down in a chicken case in bankruptcy court in Aberdeen, Mississippi, today and tomorrow. It's not a pretty place, but anyway, not like up here. But, you know, he would tell you, if IDEM and the other state officials and the EPA would do what they were supposed to do and just follow their own rules, whether they have bird limits or not. I understand you got, what, 55,000 before you...
30,000.
30,000 before you even have any control over them, that we wouldn't have these cases. We would be doing something else.
And we're just, here in Washington County, we're just trying to capture operations that fall below those state numbers. And trying to put a balanced ordinance together. But we don't, right now, we don't have any control over that CFO your clients are worried about. You know, if we pass this ordinance, we'll have some, but we can't, I mean, we literally cannot do anything about it today. You know, if it's a regulated operation above 30,000 birds, then they're gonna have to meet the IDEM regulations. And if they don't, it's a matter for the state. Because we actually cannot cross-state what the state regulates, we can't do anything about it.
Right, I understand that. Okay. Anything else? Thank you.
Thank you.
Mr.
Thank
Chairman.
you. Any more discussion? Brought him for our taking in the next one.
I kind of have something to say. I don't know, I think most of the people know in here that under normal production practices, there is a time when there might not be animals in the facilities. And so I want to make that clear. It's not like people might just pull out animals to deliver them. There are normal times during certain types of production when there might not be birds in a barn or hogs in a barn.
Of course.
And so
But
I
what-
wanted to make sure that that was clear. It's
Oh,
not
there's no
like-
question. You have 2.5 hog cycles in any barn in one of these hog production facilities, finishing facility, in any given calendar year.
Right, and
The
it's-
problem is when you have the individual who can decide when he's going to monitor and when he doesn't, and he picks the times when they're empty to go in
But
there.
we didn't want it to appear that he pulled the animals out so that he could.
Well, I didn't say that he pulled them out. He said,
But I wanted to make it clear.
okay,
Making sure.
I'm making it
No one else
clear
knew that
that no one
information.
thinks.
okay,
Thank
thank you.
you.
And also, just at this point, because of my earlier comments, Dr. Ebert didn't come, wasn't asked to testify as to anything, to provide an opinion as to anything. All he did was address comments that were made in a published report presented to this planning commission, and wanted the opportunity to address them as the author or participant, a participating author of the study. And to the extent that any comments are made about his credibility or lack of credibility, to me, I'd say are largely irrelevant because that wasn't addressed. All he did was suggest that when we asked him if he had any suggestions for us, he says, I really think you need to consider wind and how that might affect your neighbors and in your ordinance if at all possible, and directed us to a
Citizens Trail.
Okay?
My first question would be, some of these my concern on some of these ordinances are, how much, there is no ordinance that says how many chicken houses can be in a defined area, is that right? So where my property sits, 25 chicken houses could go in all around my property, is that correct? Okay, that's where my concern is. That's what I'm worried about. My family's been in this county for 2-3 generations. I've lived here my whole life since I was 12 years old. My mom grew up here. All of her brothers and sisters grew up here. My granddaddy built the house that I will be moving into very soon. So I am a part of this community and have been a part of this community for a long time. And I plan on staying here. I want my kids to be here. What I'm afraid of is that more and more and more and more chicken houses are going to come around. And I can remember when I was a kid, I could be outside. I could play. There was no stench around my grandma's house. Now, there are about 9 chicken houses within a mile radius of my home. The first set of chicken houses that went in, it wasn't a big deal. It really wasn't. The wind kept most of it from being around. Occasionally you smelled it. But it's starting to get worse. And I'm afraid. My kids have asthma. I've had histoplasmosis, which is what's dubbed the bird disease. And I was 20-something years old when I got it. It is prevalent in this area. It scares me that there would be more and more and more and more and more chicken houses, and that we, as a community, and I'm not saying that we shouldn't have chicken houses, that's not what I'm saying. What I'm scared of is that we
Let's
may
address
get,
the Plan Commission.
oh, I'm sorry, that we may get so many that our community goes downhill. People won't want to come here because it smells. People won't want to buy homes. My property value has dropped 40 grand. There's 3 new chicken houses, maybe 2 football fields away. I'm concerned. I've settled here. I lived here. I don't want to lose my property value. I want other people to enjoy what I have, what we all have. A great community, great country. It's good living out here. But if there's no regulation on how many houses are going to go up everywhere, well, the next thing you know, we've got chicken houses, all around my house, and then people aren't going to want to be here. They will pack their stuff and they will move. And I think, because I hear the snickers in the background, I'm quite sure they're thinking, well, go ahead and leave. Well, that's fine, but someday there won't be anybody else to help, around and keep our community going. And so I'm asking you to be thinking about, when is it too many chicken houses? Within a mile radius of my house, there's 9. I find that plenty, but at any given time, any one of the farmers around me can put up any more than they want to, and I don't think that's okay. I think we as a community have to have balance. We all want balance. November, turkey houses went in. This is the city water. This is from my well. Since November, after the turkey houses were put in, I can't use that water. I can't bathe in it. I can't wash my clothes in it. And I would love to get city water, except city water says it's going to cost me 20 grand to put water to my house, when the turkey houses right down the road got it for free because he sits on the board, which I'm going to address that too. But I know 2 years ago, maybe 3 years ago, there was not enough water for the citizens of our county. We were in a water shortage, but we're sending water to the turkey houses. So what happens when we're in a water shortage again? Someone's going to say, well, the turkey houses can't have water? Somehow I doubt that. So it's going to be the citizens of Washington County that will be without. So how many more turkey houses and chicken houses are we going to have that's going to take water from our community? Now, if there's plenty of water, and we can flow it to all of the turkey houses and not lose water pressure and not lose the kind of living that we're used to, then I'm not complaining. And it's, again, I'm not complaining about the chicken and turkey houses, but at some point, there's going to be too many. At some point, it might affect your home. At some point, it's going to affect our children. Because the disease and the nasty stuff that comes from this, we may not even know. We may not even know what it can cause. And so I'm just, another part of the ordinance may be to look at how many chicken houses do we want in our county overall? And then make sure they're spread out in our community so they're not all grouped up together. And so not certain residents are smelling all the stink and certain are not. And I would hope, my hope honestly, is that they're using high technology or a lot of technology to keep the stench out, because the technology is there. They can put it up in the turkey houses, and I don't know if the Plan Commission can even regulate that. I don't know. I'm just coming to you as a citizen and a homeowner in this county that I love and don't want to leave. That's it. That's all I have. Thank you for listening.
I got a question.
Sure.
Have you had that water tested?
I have tried. God knows I have tried to get a well guy out. We've called Dale Weller. We've called people out of Bedford. Nobody will come and look at it. Dale said he's covered up with doing turkey houses.
You can have it tested.
The health department does that for free.
Well, we sent a sample and it cost $10 to send it, and I've sent it twice, and both times it comes back inconclusive because they say they don't get it soon enough, which tells me that I need to drive it to Indy myself so that it gets there in time.
There's a place
And
in Albany called Environmental Consultants that test water all the time.
tell me that
It's
again.
down behind Derby Dinner Playhouse. I think the actual address is Clarksville.
Environmental what?
Consultants?
Okay. And you said it's behind Derby Dinner?
It's behind Derby Dinner, yes. It's a kind of a nondescript building. It's not that easy to see, but
Okay.
You can Google their address.
And you say they do that too?
Yes, they do all kinds of water testing. They do other types of testing as well.
Well, as you can see, there's black, almost what I call soot in it.
You may have stated your address when you started speaking initially, but could you tell us again where you live?
2025 West Vincennes Trail. That one right there has city water. The other address is my grandmother's address where we are moving. And that address is 7053 South Halo Road.
South Taylor?
Halo, it's actually Hollow. It's supposed to be Halo, but they spelled it Hallow. Whoever put the sign up. Yes, ma'am.
Is that the South Hollow Road address is the well water?
Is the well water. And that's the reason why we went, because originally we were moving here, and we went back to the other house because this, and the other house actually it's up for sale. It's on the market.
Is there someone living at that residence?
My dad is staying there, yes.
Okay. So, has the well been not in use for?
No, it's been in use. There's been someone living in the house.
Okay.
It just hasn't, we went from decent water, it was decent, it has the sulfur smell. It was decent water, and then in November, and this is actually good because it was solid black. It was solid black, and we treated it, and it got, the smell was terrible.
You do understand that sulfur water has a content to it that will turn black when it settles.
It hasn't been sitting though. It's been in
But you're
use.
saying that you got a display right there. You can say that you see black stuff in the bottom, and I guess that water's been sitting.
No. This was taken just right before we came here.
Okay, all right,
It was taken straight from my tap at 6:15 p.m.
all right.
And all the years that I've been in my grandmother's house, never have I seen the water like this.
All right.
The water's always been clear.
It'd be very interesting to know what that is.
Trust me, I will. I'll check into this. I work a lot of hours. I don't get a chance. And this summer, my intention was to drive it to Indy myself and get the results.
Well, I think that you've got a facility here.
I think I will check into that this week. Thank you very much.
Thank you. Is there any questions for Lori at this time? If not, at this time, I know we're kind of lengthy in the meeting and stuff, but we always kind of open this up. And I kind of hesitate with the large amount in there, but if, I would like to give the opportunity for the audience to speak to us. We're giving this as a courtesy because we are, as a planning commission, as citizens ourselves, trying to drive as many comments and concerns as we develop these ordinances and stuff. So I don't have a list, and this is not a public hearing, okay? This is not a public hearing, but I would allow you 2 or 3 minutes, if you would like to speak in front of it. Please courteously hand your hands up and thank you. Rhonda?
Why was the 1,500 square feet taken out of the ordinance?
When
15,000 square feet, because if you don't have that in there, you have building setups that will not be regulated, and will be back at square one, like we have been a couple years ago. So if you don't regulate the size, these buildings are specific size. If you don't regulate the size and do it knowingly, you still let unregulated poultry setup, and when I say regulated, I mean this needs to be for both the benefit of the farmer as well as the residents. If they're not regulated, then you get into this kind of thing. So why was it taken out of the ordinance?
I don't know if it ever was.
Was it in there?
It wasn't.
Yeah, it was proposed.
When it was proposed, it never even
That
worked.
we talked about this at the
Okay.
And I think her point is, what if what if a barn doesn't have has a capacity, but isn't utilized to that capacity, or maybe at various times? And so, I think the thing is whether it's the state's threshold of when IDM regulations apply, or when Washington County's threshold of when our regulations apply, is going to vary by a handful of heads of livestock, one way or the other. Then maybe it does make sense to put in a square footage, because to at least account for the capacity, even if the numbers aren't there today, they could be 6 months from now or something. Is that what you're getting at?
Yes. I mean, there are several houses that, like laying hens or something, some of that nature. The numbers are low, and yet they could still, we could still put a building there, okay? So it's unregulated. You've got this 40-some feet by 500-foot long building next to your house, and, there's a lot of anger that would come from that, okay? So once it's established, what's there to stop, the regulation? I mean, it's not regulated.
What if somebody puts a riding barn in for 15,000 square feet and maybe has 4 or 5 horses riding? Do you want to regulate that?
Get a variance. Get a waiver from your neighbor.
I think that what we tried to do was address manure loads. And we tried to do it in a scientific manner as far as what the animal actually produces.
There are several operations, there are several operations that fall below the number. And I'm just giving you a heads up. Also, I want to remark on the housing. It's not equal to compare a CAFO operation or whatever to a home. When the farmer, God bless you, gets a waiver for their own building, their own home. If you're looking to go ahead and regulate housing, then you need to take the exemption away from the farmer. That's the only equality. If you're looking for equality, that's the equality. It's not the CAFO, it's not the commercial operation. That's what's going to anger the population. Real zoning. Well.
Okay. Thank you, Rhonda. Recognize?
Tyson Foods. Home address is 1507 Creekstone Drive, Corydon, Indiana. I'll be brief.
Are you representing other producers out here?
Uh,
I'd please like for one of the citizens to identify and defer for you to speak.
We had prearranged that, so I don't know if I officially can speak for them or not. Hopefully, in my comments, I do cover some of their concerns.
All right.
Just as far as our industry and what we do, my grandfather, don't think I've shared this story. My grandfather started out growing chickens. He was a farmer. He had chicken houses. He spent 30 years of his life doing that. He passed away when he was 88 years old with old age. My father, he went to work for Tyson Foods, been with the company when he retired 47 years. I've been with the company for 26 years. We have worked with lots of farmers over the years between my father and myself, and what we do, it is a noble business. We produce quality food products at an affordable price. We don't duck our heads for what we do. We're proud of what we do. The other thing I'd like to say to the board is I want to thank the members of the board for your hard work. The beginning of the meeting tonight, we went over the proposed ordinance where we're at today. I think we're making good progress. We're getting closer, I think, to something that I think most people in Washington County can live with and work with. It's a benefit to all sides. There is give and take. Not everybody's going to get everything they want. We've learned to accept that through this process. But I do appreciate the board's hard work. I started coming to these meetings last October, and it's been a long road. So appreciate what you guys have done. The only point on the ordinance I've got, proposed ordinance at this time, is section 701.2.1, paragraph D. The 200-foot setback from property lines. Again, IDEM's reg is 100 feet. Again, not everybody's going to get what they want. I would ask, on my behalf, I would ask that be looked at again. Maybe a compromise there of 150 feet setback. Split that from what we're asking here to what the state has. Last comment, and this is something that my producers, and I appreciate them all being here tonight, representing their families, what they do for a living. On Fox News, I was checking the news, and today Congress is asking questions of EPA. EPA has turned loose personal information of farmers and ranchers across the United States to two different environmental, in our opinion, environmental extremist groups. Personal information. Farming in America today is under attack. It is under attack from all directions. Again, we're proud of what we do. We think it's a noble business. We're producing quality food products at a reasonable price for Americans across this country. If this continues down the path it will, and maybe we won't, but maybe our children or grandchildren, someday a lot bigger portion of their income will go towards buying food, and a lot more people will go hungry. So those are my comments. I ask the board if you have any questions for me tonight.
Any questions?
Thank you for the opportunity.
Thank you. You're quite welcome. Thank you.
Could you tell me your name again? I'm sorry, I forgot.
David Whittington.
Anybody else? Yes, John Rogers.
Donald Rogers, Salem, Indiana, Wackenhart Lane. I think I was on the agenda for about 5, 6, 7, 8 minutes.
No, you weren't. You never asked to be on.
Was I? I called you and set up Lori.
Yes.
Called me and set up Lori. but I also had 8 minutes for myself, which I called you 1 week prior to that.
Let's go ahead. Let's go ahead.
Okay. Thank you very much. What I wanted to address to the commissioners, if I could, for the land planning use, is that, they say, I just heard the factory farms and the Tyson Purdue's and Farbest feel like they're under attack. We feel like we're under attack. I mean, we have a 750-foot ordinance for a certain amount. Tyson, Purdue, and Farbest come in and say, hey, we can't work with that. We need a better deal so we can construct more when you reduce the ordinance down to, or the zoning, put in a zoning for 400 foot from boundary, or better yet, 200 foot from boundary, or better yet, 150 foot from boundary. Now, everybody's looking at the distance from dwelling. Nobody's looking at the distance from the person with whatever conditions they're in. Some might have emphysema, some may have some sort of disease or some sort of medical condition. Nobody's looking for that. Okay? I'm a healthy person. I am a farmer. I know a lot of people, if you think that I'm from the manufacturing sector, which I am, 27 years from the manufacturing industry. I own 130 acres, cattle farm, down in Taylorsville, Kentucky. Proud farmer. I've been farming in various areas all my life. It's hard work, and it's proud work, and it's honest work. What we're trying to create an imagery here, this Washington County, that it's way in the remote area where there's no chance of anything but factory farming. I hear 98 million check receipts were written for a year for the whole county. 98 million. Is that the best we can do? Why not have a Johnson Control facility out here that would hire 60 employees rather than create 60 factory farm facilities that people can have better use for their farms if you just go out and say, hey, what about this? What about the benefits? We got a benefit package for you. Now, would some people say, okay, let's go into the factory farm, I don't need a benefits package? What about health insurance, vision? What about dental? What about workman's compensation if you get hurt and you can't operate your farm? You're incapacitated for a certain period of time. What about a vacation, paid holidays, grievance days? You're going to go to your funeral and somebody calls up, you got to get up here because the trucks are here to load, nobody's here to do it? No flip a coin? I hear a lot of people talking about factory farms. Factory farm, factory farms. There's a difference. Farming cattle. I'd love to live next to 100 cattle on 100 acres. It's great. Wake up in the morning, drink your coffee, hear the moos, and you go on with your day. A factory farm produces harmful substances, health-wise and financially, to the person next door. And you're also encroaching on somebody's land with whatever you may want to do with that land. It just doesn't make sense to me that right now, when I harped about the manufacturing industry and how nobody's out there trying to pull in any type of manufacturing into our industrial parks to create some sort of influx of people to move into this county, to create a bigger tax base, and to create a better life for that person with a good benefits package. They own a factory farm, and either the husband or the wife has to go out to find the benefits package. They got kids. Most of them do. What are they going to do when they get sick? Let's sell the farm. Okay, I think there needs to be a lot more to offer here. And if you go out and produce 60 more factory farms in the various areas, especially if they all go to the east, a manufacturing sector needs a site plan. They need a mathematical model of who's going to be supporting their facility. And that's going to be wiped off the slate. They're not going to be able to look at this county if the people 39% of the people that live here work remotely outside of this county, to Louisville, to Clark County, to Floyd County. They're the ones that you know, they got jobs out there, real good jobs. I'm not talking about Walmart jobs where you work a minimum of or a maximum of 30 hours a week just so they can avoid a benefits package. I'm talking about $16 an hour jobs, 20, 30, 40, maybe a salary job of 70,000, 80. For the person, you know, they can do something else with their farm, with their land. Heck, why not? It's a great opportunity. Right now, being involved in the manufacturing industry for 27 years, it's the first time where I've seen so many expanding companies where products are falling out the dock door because you don't have enough room. People are parking in the grass because there's not enough parking space. They're looking to expand, expand, expand. You can easily Google it, Indiana expansion. It'll just pop up. You'll go from page to page to page to page. We sit next to Clark County. We sit next to Floyd County. We sit next to Louisville, which is the 98th recession buster city in the whole United States. Columbus being number 1. Indiana, the number 2 state for manufacturing. We're passing up a big opportunity here. We had a recession. Half of the manufacturers shut down, approximately. Now we're seeing an uplift to the economy, mainly in the automotive industry. Now the people that are left in business are taking on more work, plus their competitors' work, because they went out of business. You see how this thing works? They're needing to expand. There's a lot of satellite companies supplying Toyota in Indiana, Toyota in Kentucky, Ford Motor, Plant 1 and 2, General Motors. There's a new hybrid company that's right now, there's production lines being built. There's a factory being built in Indianapolis for the hybrid model. That's going to boom Delco Remy, but they're waiting for that to happen. Grab them. They're not the only ones. There's other people out there, and I don't hear anybody talking about bringing in good paying jobs with benefits to this county. You just want to hand factory farms. Here.
Excuse me, it's been over 8 minutes.
Okay, thank you very much.
I have a couple of things.
Sure.
As a planning commission, how do you propose that we would go about making industry move to Washington County to do this?
Well, I heard somebody saying that nobody's coming into the county commission saying, can I build a factory here? You're not going to see that. Manufacturing companies are sterling to the United States. That's the backbone of this nation. You have to go in and bargain and bid and give incentives and say, hey.
As a planning commission, you're not listening to my question.
Okay.
We can deal with issues of land use. We don't make incentives packages. We don't put that's for the economic partnership. Economic partnership. That's what they're doing.
I refer you to them and ask you that if you have some ideas of who might be looking to expand, that you please approach them and get an inside track, because we now have, the city's hired an economic development director separate from the Growth Partnership. There's a county board called the Washington County Economic Growth Partnership. These ideas can be addressed there. If you don't believe that just because you've been attending planning commission meetings and don't hear us talking about economic development, that's not going on in Washington County, that's just not the statutory function of this board.
Okay.
You're giving your ideas to the wrong governing body.
Why is there?
This is not, this is what we handle. That's why we're talking about it.
Okay.
If you need to
Great.
talk to someone about putting in factories and high-paying jobs, there's boards that deal with that stuff in this county.
And who are actually doing more than.
Why is this room filled with factory farm initiatives here?
We're dealing with a plan commission and land use. That's why.
And dealing with writing an ordinance about.
That affect them directly.
Yeah, exactly.
You know,
You talk about social things as far as economic packages and medical type of things that we have no impact on. What we have to work with is for land use proposed into this county. Your direction with all these industries and stuff needs to be directed toward the economic growth partnership and to the channels of that mechanism.
So you would never see them? You would never see the CEOs of manufacturing here in this thing right here?
Not unless they came in and wanted a special exception on the ordinance that isn't even passed yet. What we're doing tonight is talking about an ordinance on
Yeah.
land use,
Well,
the zoning ordinance.
as far as land use with the factory farms, let's go back to that.
No, let's go.
Let's don't go back to
We're out of
that.
time. We have given you your time.
And I have one more comment to make. You said something about how the factory Tyson project came in here and said that the 750-foot setback didn't work for them, and that's why we changed it to 400 feet. They had zero input on us changing the ordinance. They were never consulted. It had nothing to do with it. We changed it to the state guidelines that I then set forth. That's where those numbers came from.
Well, you got to check your records. You got to check your tapes and records, because I've been to several meetings here and I heard that. 750 foot is not acceptable.
The original county ordinance was, that the commissioners passed several years ago, that 750 feet was what they had passed, nothing to do with what we passed.
There was no planning commission even around. The county commissioners passed that ordinance.
No, but it was still voiced. It was still voiced by Farbest, Purdue, and Tyson that 750 foot is not acceptable for them to.
But it didn't have any bearing on what this commission did. We chose the 400 foot early on in this process because it matched the state IDEM regulation, not because of any special interests outside. We did it for simplicity.
Well, this county's worth a lot more than what, it's worth a lot more.
Thank you, Don.
Thank you very much.
Yeah, hand up. Yes.
Yes, my name is Diane Turner. My address is 7305 North Delaney Park Road, but it's Scottsburg.
Okay.
Washington County though. But I've got a lot of things to address. One of the things that was talking about the health issues, when I was little, my mom had chickens, about 15, 20 maybe. Somewhere along the line, from her chickens, I got histoplasmosis. It's crystallized in my lungs. I just seen a cardiologist the other day. I still have problems from that. And my surgeon told me that it would complicate every surgery that I had from now on because of my breathing problems. I also have allergy-induced asthma. If they was to put something like a chicken house right in front of, across the road from our house, the wind blows down the mountain and comes right straight to our house, it would bring all that over there. And histoplasmosis, I don't know if anyone realizes what it is. It's from the manure. The birds and pigeons and chickens carry this disease. My son was playing in a barn and looked up and some dust fell in his eye. He's now legally blind from histoplasmosis. So it's not just one area or two. It can settle anywhere in your body. But that is a health risk. If they put a chicken barn in front of our house, I would have to move. And we live out in the country, and so I was concerned about the zoning anyway because of the different things between town and country. People live in the country so they can have freedom, so they can be just fresh air and things. Where I live, we have no city water, even though it's 2 miles up the road at the park. It cost us $10,000 to get city water down to my house. We have no city sewage. If we get the internet, in town it's like $10. Out to our place it's like $50 a month. And the internet I used to use was dial-up, which is drop an ad and it's not worth the money. And we are not even district for a library card. We can purchase a library card, which is not my problem. The problem is that the library card, if you have to pay for it, it's not reciprocal in other libraries. And so I was wanting to do like a voluntary tax, like property tax, that people, if they want to use the library, they could pay this tax. That way they could get a card without paying for it, and it can be used at other libraries. like Scottsburg, Seymour, whatever. And my daughter-in-law has been trying to get her address switched out to my place because my son's an evangelist and they're always traveling. They're selling their home, but they're still members of Washington County. They cannot get anyone to give them just an address at my house. If they have no address and they are not considered citizens of Washington County, then they're also probably not considered citizens of Indiana, which would make them no citizen of the United States. And she's been trying her best to get one, and they won't give it to her. Plus, the fact where we live, what I'd like to do is be grouped into just one in Washington County. Our lights come from Brownstown, our phone comes from Salem, and our mail comes from Scottsburg. You try telling people that, and they're looking at you like they think you're crazy, you know. And you're saying, I'm in this little corner here, and if we're going to be zoned, why can't all of Washington County have all of the amenities? Is what my point is. And, yes, you did. And you told me I had valid points and show up, so I thought that would be nice.
I told you also that you had several issues, and there were several entities that addressed those different issues as far as your library card and stuff like that. Salem Library is basically Washington Township, City of Salem. The rest of the county is not taxed on the library. It was defeated, you know, as far as the tax on that and stuff. I understand your plight with your different things in that. We can't take salt out of ocean water either. So just to clarify that too.
Yes, sir.
So there are certain things we can do. I mean, as far as your response, as far as your hotel reasons and locations, is very qualified as far as us to take a look and address and that. So, you know, I would like to visit with you and try to address those different entities that you need to work with your different concerns. I don't think we can do anything with the utilities because I get my electricity from Jackson County, the Jackson County RMC. So we're always going to get it from Jackson County. So.
Well, is there anything we can do about the redistricting thing? Because I'm not district in an area, I have no library district somehow or another.
Yeah, that would have to be something that would go in front of the county council, wouldn't it?
It's actually left up to the township advisory boards and the trustee, and they've all voted down. They've had an opportunity to join the Salem Washington Township Library, and they don't want to support it tax-wise, and so just the city and this township.
Well, I was wondering why we couldn't put like just a voluntary, like people could, you know, put it on a questionnaire, you know, like, would you want to do this? And let people attach it to their taxes if they want it. That way it would give us choices as individuals.
You can participate at the Salem Washington Township Library by paying a fee. I don't know how much that fee is.
Well, that's not the problem. The problem of it is I can't use it at other libraries because I had a daughter-in-law that homeschooled. So she tried to get other library books from different libraries and things for her children. She couldn't do it because we had to pay for the card. If the card had just been given to us because we was in the township, she could have got them. And that's something I don't understand when they want everyone to join a literacy thing and then we're not allowed to.
Let me give you some advice. Talk to your township trustee and then maybe visit with the library board whenever they meet and address it to the library board.
How do I find out all this?
Well, if you came to the commissioners, John Foltz, one of the commissioners.
Yeah, he is on board. Contact John Foltz, he's the commissioner.
All right, thank you.
Let me give you another piece of advice. Try to find the cheapest library card you can at any of the libraries in the state of Indiana, and then utilize that particular library and utilize their interlibrary loan. The libraries will trade books back and forth. So that's...
Yeah.
If you've got a library card, generally that will cover interlibrary loan.
Okay, thank you.
Thank you very much. Good talk. Any more questions? Yes?
No question, but a comment.
All right.
Real brief.
All right.
Tim Churchman, 415 South Shorts Corner Road. Just just as a county resident and farmer, turkey producer, corn crops, soybeans, whatever, I just ask that the board just continue to look out for all residents and be fair with this ordinance. We realize it's gonna happen. We just look for fairness. Good, thanks.
Thank you. Any other comments? Yes, Mike?
Michael Gelfinger, 6342 West Rosebud Road. I feel that there should be some sort of reciprocal, for the simple fact that if you're gonna regulate what you do with my land, or what I can do with my land, why should anybody else be able to come in and stop me from expanding? Or why should they be free to do what they want with their land if I'm not free to do what I want with my land? And I also believe that there should be some sort, I mean, when does a house, like y'all put the chicken houses as being, after 5 years, they're automatically kicked out because they're not used? Well, what about all the condemned houses around this county? There's tons of double wides, there's tons of houses, little houses that people haven't lived in 10 years. Should they be stopping us from building if nobody lives there?
Not according to the ordinance.
Of course it is.
The ordinance says they gotta be 6 months.
Somebody's gotta live there 6 out of 12 months.
Abandoned houses don't count. They can't keep you from doing it.
Okay. Anything else, Margaret?
I
Okay.
have a statement.
Yes.
My name's Karen Wishmeyer. I'm at 8437 North Pumpkin Center West Road, and it, again, is a Scottsburg address. I used to work for the largest hog producer in the state of Indiana, and I'm raised on a family farm. So I've heard both sides of the story here tonight, and I've actually attended meetings in Lafayette before for my company that I used to work for. And you all have valid points about your air and how it smells and all this stuff, and I get what you're saying. And I hear the complaints about histoplasmosis and how it's caused from birds and all this stuff. It's actually birds in general. So everybody out there who is telling everyone out here that it's these poultry farmers that are doing it, it's not just the poultry farmer. It's birds in general. So you're going to get that whether you're on a farm or whether you're in the city, first of all. So these farmers out here are doing this job because it's their choice. It's their way of life. It's what they want to do. The state has regulations on the sizes of buildings. They have regulations on the number of buildings. So there is a chance that you're not going to be overpopulated by 20-some buildings, okay? So don't think that the American farmer out here is trying to kill off any local resident. They're not. They're not here to kill you off. They're here to feed you. So if you have a problem with it, you come to the board like this and you state your problem about it. But you also need to be educated on both sides of it and know that you can't feed that type of opinion and say that it's totally caused by the poultry farmer, because it's not. These guys, and you can't assume that every large producer out there is a factory farmer, because what I handled at my job, those guys were not factory farmers. They were small people that sat on this side of the room that were a contract employee for a company like mine, and some of them didn't raise more than 50 hogs in their building. Some didn't raise more than 100 head turkeys. But they're not a factory farm. So you can't assume as a resident that every large building out there is a factory farmer, because that's not the case. That's all.
All right, thank you.
Sean Ferris, 4025 West Vincennes Trail. I just have a very quick comment on the histoplasmosis, just to talk about it. I'm a respiratory therapist. I've done reports on histoplasmosis. Yes, it is all the birds, but when you get the birds in a confined area, a large amount of them, their manure fertilizes the ground, allows the spores to grow. The tractors, the farm equipment, equipment in a construction site comes in, moves the dirt, sends the spores airborne, we breathe them in. Everybody in this area is exposed to it. The people that are affected by it are the people that are immunocompromised. My niece that has cancer, anybody like that that has already got a weakened immune system. And yes, there's a chance they can be exposed to it in the town, in cities, but not like they are out in the country because the ground is moved, you have the bird, and it's not just the chickens, it's not just the turkey bats. In caves, it's the manure, it fertilizes these spores and allows them to grow. And then when this equipment comes in, there's no rain, it's dry, the wind blows it around, we all breathe it in. That's all I got.
All right. The hour is getting late. Are there any additional comments, questions? If not, I entertain a